So, an absconder is entitled for anticipatory or regular bail. This is the topic which I am going to discuss today in this video. As far as the term absconder is concerned, there is no specific definition is given in CRPC. We need to rely upon the definition of dictionary. What does abscond mean? Abscond means, as far as the definition, to go away suddenly and secretly in order to escape from somewhere. This is the definition from dictionary.cambridge.org. Now, according to another definition given by merriam.webster.com, abscond means to depart secretly and hide oneself. When there is no definition given in CRPC for absconder or to abscond, we need to rely upon certain definitions provided in the lexicons. Now, second point, who can be considered as absconder? Section 82 subclause 4 of CRPC. What does section 82 subclause 4 say? Let me read it. Provision of section 82 subclause 4 of CRPC says that if a case falls under the sections of IPC provided therein, that means certain sections are given in section 82 subclause 4. The court may declare an accused person as a proclaimed offender and not otherwise. Suppose an accused person is not within the purview of those sections provided in section 82 subclause 4, then he cannot be considered as proclaimed offender. Thus, a criminal case which does not invoke the sections provided therein, he cannot be considered as proclaimed offender, as I said. For this statement made by me or for these provisions made therein in CRPC, I need to rely upon certain judgments. First judgment is Arun Kumar Parihar versus State into bracket Government NCTD High Court of Delhi, case number CRMC 863/2020, dated, that is date of decision 26 March 2021, para number 2. Now, second issue or the answer of this video or the answer of this topic, whether proclaimed offender is entitled for anticipatory bail, the answer given by Honorable Supreme Court is no, the proclaimed offender is not entitled for anticipatory bail. I rely upon one judgment of Honorable Supreme Court in this regard. The judgment is Lavesh versus State NCT of Delhi 2012 8 SCC 730, para number 10, wherein Honorable Supreme Court held, now I read that paragraph, an absconder or the proclaimed offender is not entitled for anticipatory bail, and further observe that from these materials and information, it is clear that the present appellant was not available for interrogation and investigation and declared as absconder. Normally, the word normally is used. Normally, when the accused is absconding and declared as proclaimed offender, there is no question of granting anticipatory bail. We reiterate that when a person against whom a warrant has been issued and is absconding or concealing himself in order to avoid execution of warrant and declared as a proclaimed offender in terms of section 82 of the code is not entitled for anticipatory bail. Another case, State of Madhya Pradesh versus Pratap Sharma AIR 2014 SC 171 either or 626. Honorable Supreme Court reiterated the principle established in the case of Lavesh Kumar. Lavesh case is reiterated here and held that, now I read that particular portion. If anyone is declared as an absconder / proclaimed offender in terms of section 82 of the code, he is not entitled for anticipatory bail. The High Court failed to appreciate that it is a settled principle of law that where the accused has been declared as an absconder and has not cooperated with investigation, he should not be granted anticipatory bail. Now, on the same line, there are several judgments. I just read those judgments. Relying upon these judgments of Honorable Supreme Court, Chhattisgarh High Court in the case of Rakesh Kher versus State of Chhattisgarh rejected the anticipatory bail. Fourth one is Jayesh G. Ramani versus State of Gujarat 2004 3 GLH 270. Another judgment is Jagtar Singh versus Satyendra Kaur alias Bhavna Grover 2002 CRLR SC 807 para number 2, wherein it is said that normally when the accused are absconding, there is no question of granting anticipatory or regular bail. Another judgment is Dharmapriya Das Bapu Swami versus Ajendra Prasad criminal miscellaneous application into bracket for cancellation of bail bracket over number 2210 of 2014 Gujarat High Court para number 6, 7, 11 and 12. Another judgment, Arun Gisilal Verma versus State of Gujarat. CRI miscellaneous application number 10757 of 2011. Second one is Dilip Singh Bachubha Rana versus State of Gujarat. CRI miscellaneous application number 18050 of 2012. These are the cases of the same line wherein it was held that anticipatory bail cannot be granted in respect of the person who is an absconder. But one judgment of Honorable Himachal Pradesh which says that proclaimed offender is entitled for anticipatory bail. However, in that case the facts is little bit different and the scenario is little bit different. So considering the judgment of Honorable Supreme Court in Lavesh's case, the Honorable Himachal Pradesh, Honorable High Court of Himachal Pradesh, in the case of Mahendra Kumar versus State of Himachal Pradesh, CRMP into bracket M bracket over number 1682 of 2020, decided on 26 October 2020 in para number 11, dealing with, as I said, the case of Lavesh of Honorable Supreme Court. In para number 11, Honorable High Court of Himachal Pradesh held that, now I read that particular portion. Section 82 of CRPC neither creates any riders nor imposes any restriction in filing of anticipatory bails by proclaimed offenders. Even in Lavesh's case, while laying down the law on anticipatory bails to absconder, Honorable Supreme Court structured that pronouncement of words normally. Then after the fact of that particular case before Honorable High Court of Himachal Pradesh was discussed was discussed in that particular paragraph, and then after the legal maxim, one legal maxim is given, which the meaning of that legal maxim is the plight of the accused, which means every man's house is his safest refuge. Thus, the circumstances cannot be termed as normal for the accused, and he makes out a special case for bail. Looking to this special case, looking to the facts of the case, Honorable Himachal Pradesh decided that particular offender who is proclaimed offender to grant anticipatory bail. But that scenario was different in that case. Friends, the rule is that anticipatory bail cannot be granted, or regular bail cannot be granted to the offender. Thank you very much. I hope you like this video.